We call next number 75, Grant et al. Versus the County Council of Prince George's County, sitting as the District Council. Good morning.
Good morning. Please the court, Macy Nelson on behalf of the appellants, the citizen protestants in this case. This is a land use case arising in Prince George's County. It concerns a special exception, and we'll talk more about the administrative process in Prince George's, but at the outset, let me just say that there is a two-tiered administrative process in Prince George's. The first level is the zoning hearing examiner. The second level is the district council. As we all know, that every county in the state has an ordinance that governs the criteria for the approval of what some counties call a special exception, other counties call a conditional use. But these are a set of statutory criteria which govern a tribunal's review of an application for a special exception. There are two ordinances in Prince George's which are central to this special exception application. The first is zoning ordinance 27-317. That's the generic special exception criteria in Prince George. And the second is applicable to the use at issue in this case, which is a large format commercial retail store. And that's section 27-348.02. I mention those statutes, those ordinances, because these are the elements of the claim that the applicant must meet in order to get a approval of a special exception. And the case started with the applicant filing for an application for a special exception. The case went to the zoning hearing examiner. This is the first level administrative process. In Prince George's, there are two zoning hearing examiners. We were assigned to Examiner Nichols, who conducted a 5-day evidentiary hearing. This was a classical administrative quasi-judicial proceeding with direct and cross-examination under oath, expert testimony, lay testimony, documents, the traditional evidentiary zoning hearing. And the zoning examiner considered the criteria set forth in 27-317, considered the criteria set forth in 27-348, and issued a decision disapproving the application for this special exception. She found as a fact that the applicant failed to prove compliance with the requirements of 27-317 and 27-348. Now, in the Prince George's County regulatory scheme, one has the right to file exceptions and go to the second tier, which is the district council. And the district council, this is jargon that we live with every day, but the district council is the county council sitting in the capacity as the appellate body for these land use matters. So when we say the district council, it's the county council sitting in this role as the tribunal reviewing the decision of the zoning hearing examiner. The process requires the applicant or the party seeking a reversal of the zoning examiner to file exceptions. There's a hearing before the district council. This is in the nature of an argument. There's no live testimony. Lawyers are arguing the record. And there were two hearings. The first was on July 18, 2016, where the zoning lawyer for the applicant made his case in support of his exceptions. I argued on behalf of the citizens in support of the zoning hearing examiner's decision, and the district council asked a few questions. At the end of that hearing, or during that hearing, not once was there any reference to, by the council, the requirements in 27-317. Silence. That ordinance was never mentioned by the council during that proceeding on July 18th. There was no deliberation about any issue in the case. Now, council members asked questions, but there was no deliberation about factual issues, none whatsoever. At the conclusion of that hearing, on the afternoon of July 18th, Councilman Franklin, in whose district this property is, moved for approval and instructed staff to prepare an order. That was in the afternoon of July 18th. We came back the very next day, July 19th. And keep in mind, when we returned to the district council's hearing room, there had been no deliberation, no discussion among the council as to what the findings of fact were. And when we came back the next morning or the next day, staff counsel, principal counsel, had a 51-page opinion, final order, which is in the record, which was approved by the district council.
Mr. Nelson, as you recount what happened, let me ask the question whether this is an aberration or is this fairly typical of how the county council acting as the district council, the appellate body, as it were, here.
May I go? I think the court's asking me to go outside the record.
Well, I guess maybe I am.
The answer is it's typical. It's unequivocally typical.
Okay, I recognize you've gone outside the record.
Right. Yeah,
all right.
I mean,
you may proceed,
yeah.
Mr. Nelson.
Well,
yes.
Counsel, perhaps you could, because you appear to be conflating a process or processes. Explain to me your assertion that the district council lacks original jurisdiction in terms of special exceptions and variances related thereto. Because if I'm looking at if I'm examining the Regional District Act in conjunction with certain provisions of the zoning ordinance in Prince George's County, I come to a conclusion that they do have original jurisdiction, which means that the process that you are alluding to was not out of the ordinary relative to special exceptions and related variances. So if you could help me understand
I disagree with that in several ways. But first, I want to touch on the jurisdictional piece because that's an important piece of the story of this case. But my opening thesis is that administrative law, Maryland administrative law, requires this body, whether it has appellate or original jurisdiction, to deliberate on the facts in the case. And they didn't deliberate on the facts in the case. They delegated that to staff counsel, principal counsel, to write the finding of fact. So that was my opening point. Your Honor's question was about the jurisdiction.
only because in your brief you appear to challenge the district council having original jurisdiction in this regard. That's what I'm saying.
I most certainly do challenge that. Absolutely. But the point I'm trying to make is that my argument about deliberation stands whether or not they have appellate or original jurisdiction. But let me address the jurisdiction piece. I think it's a difficult question as to whether the district council has appellate or original jurisdiction. No appellate court has decided that question in the context of a special exception case. And I've labored through the Zimmer case, which is a different case. We're not relying on Zimmer, but it's sort of a roadmap to, it's sort of an approach to the analysis. How does one begin to analyze whether they have appellate or original jurisdiction?
Well, does Billings shed any light on that?
I say no.
And why do you say that?
Well, in Billings, the council, district council, and if I'm using jargon, I'll clear it up. They called up the case. One of the unique characteristics of the Prince George's County ordinance is the council can reach down and call a case up. Only jurisdiction in the county where in the country where you can do that. So it politicizes the land use issue. They called up the case in Billings. A citizen didn't file an appeal because they called it up. And then the council withdrew its call-up after the appeal deadline. And the citizen said, whoa, wait a minute. You can't call up a case, have us rely on that, and then dismiss the call-up. And the court said, no, you can't. This court said, no, you cannot do that. Now, in the context, there's dicta we're citing, I may have the precise 27-132F, I think, I'm doing from memory. But it's not a holding. There was no holding that the district council has original jurisdiction. And we know from the Zimmer case that to answer the question of jurisdiction, one must look at, well, what does the enabling statute say? If the enabling statute doesn't authorize it, you can't have it.
But doesn't Land Use Article 22-301 specifically say the district council can adopt zoning laws in order to allow themselves to grant special exceptions and variances? And doesn't that constitute the enabling legislation that establishes jurisdiction?
I say no, and I say, and here's why. The RDA, the enabling statute for Prince George's, is silent, does not say whether the district council has original or appellate jurisdiction. It says that the examiner and the council can decide these special exceptions. It doesn't describe the type of jurisdiction. In contrast, if you look at the enabling statutes for a charter county, Baltimore County and Anne Arundel County, for example, it says precisely that the enabling statute authorizes a board of appeals, and they can give that board appellate or original jurisdiction. Then the land use article says in those jurisdictions, but the legislative body may not serve as the board of appeals. So I say the Regional District Act is ambiguous. Then I look at the charter. What does the charter say? What does the county's constitution say about the jurisdiction of the zoning hearing examiner? It refers to a zoning hearing examiner, but it doesn't say, and it refers to an appeal of district council, but it doesn't describe the jurisdiction. So that,
if you read 22-301 of the land use article, and 22-310, and what I'm looking at is that the RDA gives the district council the authority to grant special exceptions. And then if you go to 310, it gives the district council the authority to provide for appeals. It gives the district council that enabling authority to decide what type of appeal process it chooses to have in this circumstance, does it not?
Judge Booth, my assertion is it's ambiguous. And I arrive at that conclusion by reflecting on how many years we've debated this point. It's ambiguous, I believe. That's my view. And then I compare it to the other enabling statutes, which say very precisely, they talk about the type of jurisdiction. I look at the charter for Anne Arundel County and Baltimore County, which talks about an appeal from a hearing examiner to the Board of Appeals, and then it says, in black and white, de novo review. Now, to me, that's an example of good, careful writing. Then I look at our charter in Prince George's, silence. Then I say, well, what's the legislative history say? So I go back to the creation of the zoning hearing examiner in 1971, and I go down to the county council, and I go through the archives with their assistance, and I come up with the bill file, and Councilman Francois, who was promoting this bill in 71, says this is appellate jurisdiction. And to me, that informs the question of what, when I say appellate from the appeal from the zoning examiner to the district council, I think that informs the interpretation of the ordinance. And then we have the 1979 amendment to the land use article. Now, the amicus wrote a nice brief, and their thesis is that amendment in 1979 used the word appeal, and appeal means appeal. And Judge Booth, I think what you're pointing to is language that is the basis for an argument for original jurisdiction, but it doesn't overcome the ambiguity. It's the argument of an advocate, I believe, seeking to advocate for original jurisdiction. My thesis is it's ambiguous. And then I look at the legislative history, and I look at the Attorney General's opinion from 2014 talking about and this is looking at the comprehensive plan for Mount Airy, but it's informative. This opinion is a repository of a lot of careful thought, not under the pressure of time, multiple lawyers thinking about it carefully, not some private practitioner pushing to get some job out the door by 5 p.m. And what the Attorney General said is that when we adopted Maryland's enabling statutes were really premised on the 1924 federal statute, and the whole idea was to take the politics out of it. That's the whole premise. And so I think when you look at that, and you look at Councilman Francois' statement, and you look at the effect of interpreting the ordinance the way that you just have suggested it might be interpreted, what we're doing is we're injecting politics into the land use process in a way that doesn't exist anywhere else in the state or in the country. No county in Maryland has an elected body making land use decisions. They traditionally make legislative decisions about what zone goes where, what uses are permitted in what zone, but they aren't making findings of fact as to whether someone meets the test for example, a special exception. And I think one of the downsides of that interpretation that you have just postulated is, I urge the court to think about all the land use cases that originated in Prince George's County. We've cited them all in our paper. In every case, the district council is trying to expand its authority in land use cases and has generated a disproportionate amount of land use litigation. And I think it's a direct result of the fact that the politicians are involved in the land use process. So I hope that responds to your question. But I want to go back to the delegation piece, because this is a really important piece that I think is applicable statewide in all administrative cases. The only interpretation of the evidence in this case is that the district council delegated to principal counsel, the attorney, the authority to make the findings of fact. We had 2 hearings on July 18th and July 19th. The council not once mentioned 27-317. There was not one syllable of deliberation about 27-317. And yet, in less than 24 hours, principal counsel produced a 51-page opinion with 27 pages of which outline factual findings on 27-317. Where in the world did that come from?
Mr. Nelson, doesn't that happen all the time, though, when a legislative body or a board of appeals requests that council draft findings of fact to bring back to them for deliberation and a vote at a subsequent meeting? I
disagree categorically. So this is what I think happens in the trenches is there's an administrative hearing, there's testimony for and against, and then let's take Baltimore County, for example. Then they schedule a deliberation, and people are allowed to come and observe the deliberation, and they go through there's section 502.1. The board goes through the requirements of the ordinance, and they call a vote on each element, and the staff there is taking minutes, and they put the minutes online, and then an opinion is produced. Now, in some jurisdictions, there's a staff attorney present. They don't have one in Baltimore County. Like in Anne Arundel, they have a staff attorney who writes the opinion, but the staff attorney writes the opinion after the body deliberates. Here, there was no deliberation. And let's take your thesis. Well, isn't it normal for them to assign to a lawyer the authority to write the opinion? But they never deliberated on the opinion. There is no evidence in this record, Judge Booth, that this council deliberated on the opinion.
So hypothetically, staff council has all the materials ahead of time. They prepare, a vote is taken, and council's asked to prepare findings. Council goes back, prepares said findings, sends it by email to his client. Attached are the findings of fact for tomorrow's deliberation. Let me know if you have questions. The district council returns. They have read it. If they don't have any questions, isn't that act of deliberating the act of voting in public?
I said no. I have 1 minute now. This is an important question. I say no. That doesn't meet the requirements of the law. Number one, there's no deliberation. Number two, it violates the requirements of the Open Meetings Act.
What section of the Open Meetings Act do you contend it violates?
Well, let me just reiterate. We never asserted a violation of the Open Meetings Act. We assert there was no meeting, public or private. That was our fundamental assertion. I cited the preamble of the Open Meetings Act to say this is the public policy behind public deliberation. We say there was no meeting, public or private. We say staff counsel wrote the opinion and the council never deliberated. The Court of Special Appeals said it was the Court of Special Appeals who postulated this idea of the walking quorum. And so what we talk about is, my theory is that if the Court of Special Appeals postulation is correct, if the district council circulated this opinion separately, that's an evasive device that was designed to get around the requirements of the Open Meetings Act, which requires a vacation of the approval. But our core point is there was no meeting, public or private, and that there's nothing in the law, we believe, that should support the notion that there can be this private email chain between staff counsel and the members of the district council about the findings. And even if there were, then then there should at least be this deliberation on July 19th. We have reviewed the draft opinion. We have reviewed the proposed findings of fact with respect to 27317. We agree for reasons X, Y, and Z. We have reviewed the proposed findings with respect to section 27348. We agree for reasons X, Y, and Z. There was none of that. None of that. There was no deliberation either before the opinion or after. So I think I'm probably down to about 30 seconds.
It might be. Well, I think you have a few minutes remaining in your rebuttal. So Ms. Rice will let us know when you return to the podium. Mr. Kumar.
May it please the court, counsel, if we lived in a legal world without Morgan versus United States of America, Consumer Protection Division, Anderson, and Zimmer, this case would be a case of first impression. This opinion from this court has already been written by the United States Supreme Court and this court, where it states that an administrative body can decide a case solely on the record. And how do we get there where Judge Houghton started off with regard to the original jurisdiction? It starts in Land Use Article 22206, and it's on my brief on page 24. That section is critical to the determination of the type of procedures and the jurisdiction, so to speak, that the council may exercise in deciding special exceptions, and that is as follows. The Land Use Article, the General Assembly gave the District Council the authority to create procedures, and it states permissive elements. And in Section 3, which is on page 25, it says that we can create the procedures for an examiner to make recommendations, preliminary findings. And then it says we can assign the evidentiary value that may be accorded to any of these factors. That takes us to 301, and that takes us to the bill in 1971 that created the zoning hearing examiner. When the council created the examiner, it specifically created the examiner to render preliminary determinations subject to final decision by the council. Mr. Nelson argues that it's ambiguous in the RDA, and this is a difficult question. But if you start with Morgan versus United States and you come down to the cases that have interpreted that case, it is crystal clear from just 22-206 that the council can establish an examiner and determine the type of procedure that must be followed and give the evidentiary weight of that decision, which is what occurred here. This court has made very clear there are two types of factual determinations when you have an examiner who does the heavy lifting of creating the record and giving it to the agency to make the final decision. There is credibility factual determinations and there's primary factual determinations. And amicus, in response to the amicus brief, I wrote a paragraph which is almost verbatim from the case law. In essence, pages 1 and 2 of the amicus response is what this case is about. This case is about a standard of review already created by the Court of Appeals. And that is, when you're determining factual disputes from the agency and the examiner, you must give strong reasons as to credibility determinations, and you do not have to give any deference to primary facts so long as the factual finding by the agency is supported by substantial evidence. That is what this court has said repeatedly. We are hung up here today on the question of original versus appellate jurisdiction. But the real question is, the RDA has conferred upon the council the charge to make the final decision. And in doing so, you go back to the standard of review on that final order. Mr. Nelson argues that there was no deliberation. That is false. The Open Meetings Act that triggers a meeting in a special exception specifically states you meet to consider the application. The legislative policy is for the public to see the deliberative aspect of that meeting. The Open Meetings Act does not speak to what consider means. It says you meet to consider a special exception. There were two meetings. The first day they met and they had oral argument, which has been authorized by the Supreme Court and this court as a basis in hearing the testimony. So they met on July 18th and they considered the application. Before they met on July 18th, on our brief, we cite to, in the factual section of the brief, the statement of facts, the record consisted, it's on page 6 of the brief, it consisted of the planning board's transmittal of the file, a 5-day hearing of transcripts, 102 exhibits, the examiner's decision, which Morgan and subsequent cases have said is part of the record, Walmart's exceptions, and 47 pages by the petitioners for the council to consider. Mr. Nelson argues heavily that we made up new facts, but when a body must issue a final decision, they must do so on what is in the record. The petitioners themselves submitted a 47-page document for the council's consideration. We could not just say we reverse the examiner and we grant the special exception, because that would be a violation of 25-204 and other provisions in administrative law to make findings of facts and conclusions of law.
At some point, Mr. Nelson referred to the delivery of a 51-page document by principal counsel.
That's correct.
Within 24 hours,
yes.
approximately. Now, he may have left an unsaid suggestion, but what do you have to say about that? Is that at all relevant here? What do you make of that?
I would take Judge Booth's view on this, that this is an administrative procedure created by the council pursuant to the RDA. There is a code section in the county code for hearing procedures for the district council that they can make any direction for preparation of findings of facts and conclusions of law, which we believe is consistent with 22-206, which is establishing procedures for hearings for these types of proceedings. There's no question, Your Honor, I am the principal counsel to the district council. I am charged when they give direction at any time during the proceedings to create a legal document or a document for adoption. I created the document. I wrote the document. Just like Judge Booth said, the file was transmitted to us months in advance. I am not sitting only at the hearing in isolation. I review the file. I sometimes talk to a member individually before the hearing regarding the file. This is not something created in 24 hours.
Well, the 51-page opinion goes through each of the sections that had to be discussed.
Yes.
For the special exception, and makes certain decisions about those comments about them. Were they discussed by the district council at the July 18th? There's this oral argument.
That's correct.
They didn't discuss
No, sir.
those. So how did you know what to put in?
Well, there's two ways that I am provided with information as to the direction. Before the hearing, I speak to members. I never speak to members. We have this rule. Before the 11-member panel took office, we now have 11 members as a district council. We used to have 9. We would never meet with more than 2 members, sometimes 3 at a time, meaning me or any legal staff.
So you're saying a court of special appeals speculation of a going from member to member to member is correct?
Yes, and I've done that before. And I would never mislead the court that I have never met with the members individually to discuss what will be in a final order. I do it. I do not find that to be a violation of the Open Meetings Act.
So you're tabulating basically the votes on the different elements.
That's correct.
In advance of the meeting.
Yes, Your Honor.
And it's not discussed at the meeting at all.
Your Honor, at the meeting, the council, as a matter of practice, never go through line for line the elements of the zoning ordinance in arriving at a decision. The reason we believe that that is not required is because the law requires the final decision to be in writing. Even assuming for argument's sake that they did so, that would have no weight with regard to what comes into the final document that is subject to judicial review.
So you didn't have to wait till July 18th, under your view, to do the 51-page memo. You could have walked it around the day before.
Yes, because the way it works in the counties, because it's district courtesy, when I get direction to take on a case, I review the records just like a member would walk into the clerk's office and read the file. And then in some very highly contested cases, we're sometimes drafting 2 separate types of decisions because we don't know where the votes may go. But in this particular case, when the council met to consider the application on the 18th, they had all of the information in the file. Staff is directed to prepare the order, and the next day we adopted the order. It's our view at that juncture when they adopt the order, that is the final decision that's subject to judicial review, and there is no violation of the Open Meetings Act because the Open Meetings Act only required the council to meet in an open meeting to consider the application. And there is no evidence in the record that we met behind closed doors in violation of a quorum or violation of the Open Meetings Act.
But it sounds like the consideration of your 51-page opinion took place each time you went to each member and they each considered it, and then you were able to accumulate their considerations and come up with the end result. And if I understand your theory correctly, they could have done it the week before
Well, we get direction sometimes in advance as to where the council would like to go on an application, but we never do it outside in a quorum, or we never meet beyond one or two members to discuss.
So you do it 2 by 2 or 3 by 3?
Sometimes 1 by 1 I do it.
4 by 4?
No, I never meet with 4 members at a time. I've never done that. And we do it for a reason, because when we had 9 members, we always had this rule never to meet, even when they're sitting on the dais. If one member walks off, we run back and bring them back so we have a quorum during the meeting. It's just something we do as staff.
Mr. Kumar, are you aware of any statute or case that describes or provides parameters for what constitutes deliberation? In other words, is there any guidance that the court could look to that says, well, to deliberate, they have to consider each of the written findings, or is it sufficient to have written findings and affirmatively vote to accept them?
We couldn't find any. In fact, we looked at the Open Meetings Act for a definition. It only defines meet. It does not define deliberation. The word deliberation is coming from the legislative policy that sets forth that you have to have an open meeting so the public can see the public body deliberate. Mr. Nelson is using the word deliberate to go behind closed doors, non-violation of the Open Meetings Act, staff attorney to a member, attorney-client privilege kind of conduct. He wants that to be deliberative. He wants that to be part of the open meetings. If the law provided for that, or if there's a provision in the law that required us to do that and we didn't do it, we would not be in this position, and we would have committed a violation.
How would you define consider in the context of what we have before us today?
Once again, we looked at the Open Meetings Act. It doesn't define consider.
How would you define it?
I would define consider just like this body is sitting here, considering this argument, which Morgan and other cases have authorized. That is hearing the evidence or hearing the record. You do not have to see the live testimony. For example, this body doesn't have to see how the council deliberated on July 18th or 19th to have heard arguments in this case. And it's the same thing that Morgan and other cases say, that you can have that process in place, and that is a considered review of the case. Yorkin and other cases from this court similarly talk about the position that it's the vote on the application that is that is required before the action of the written order is executed that is subject to judicial review.
And so do I understand your position that consider doesn't include deliberation? I assume it doesn't within your definition as you've advanced it. Perhaps I misunderstand.
No, I'm saying that the Open Meetings Act does not define deliberation or consideration. What it does, it says you have to meet to consider the application, and the legislative policy that the public should be entitled to see the deliberation is how the Act defines it. Without specifically defining the word deliberation or consideration, we met and we considered the application. That I can offer to the court, for a lack of a better word of a definition, is what consider means.
Do you feel that does your position, and maybe I'm just confused here, of course, but is your argument that the Open Meetings Act does not require that the body deliberate in an open meeting?
No. I'm saying when we met to consider the application, that was the deliberation.
Consideration could be as little bit as just voting. How about
that is correct.
So all they have to do is file in and vote.
Well, no. The requirement is you have to meet. You have to meet in an open meeting, and it has to be a quorum when you're considering the application.
So a quorum files in and votes, and
correct.
Then they leave.
On Yorkin and other cases, there are some cases in Montgomery County and I believe one in Anne Arundel County that this court decided, even when a member did not participate at the hearing, can vote so long as they have read the record. And that, I believe, is what the Open Meeting Act is talking about. One, you have to meet in a quorum as a public body when you're granting a special exception, which is what occurred here.
We have posed additional questions to you. We will not subtract that from your time, Ms. Bruce, but at this point, we'll ask you to stand down.
Thank you.
Ms. Bruce?
If it please the court, Celeste Bruce on behalf of the actual applicant. We filed this application to expand an existing building located in Clinton, Maryland. We end up in the Court of Appeals arguing about issues that really tangentially touch on our special exception and variance, because if we're going to look at the record backwards and see what the district council did, regardless of how it deliberated, what it considered, whatever it may be, we met the standard for the special exception, we met the standard for the variance, we should be allowed to move forward. And we are here in front of you because we are now talking about, once again, one, whether or not the district council has original jurisdiction, which should have been answered many years ago. Judge Atkins gave us, in Billings, gave us her answer, this court's answer as to who has original jurisdiction.
It wasn't just Billings, it's also 27132F, correct?
27132F is the outcome of the delegation of original jurisdiction to the district council from the RDA. So General Assembly gives district council the original jurisdiction through the RDA, and then Prince George's County enacted any number of ordinances regarding zoning, and that culminated in 27132F, which then gives us what is the jurisdiction that the district council believed it gave to the zoning hearing examiner's office versus what it retained for itself. As Mr. Kumar said, this is not new in administrative law. Agencies do this all the time. You have a head of an administrative agency, and he or she delegates downward, and we also have provisions where they can delegate to an ALJ at the Office of Administrative Hearings. The agency doesn't necessarily, unless it wants to, give up its original jurisdiction. The agency head still has the authority to issue the final decision. No different here. The district council retained for itself the original jurisdiction granted to it under the RDA. Zimmer, again, has become the beginning and the end of all land use cases in Prince George's County, whether it was meant to or not. But Judge Harrell and this court painstakingly went through the differences between zoning and planning and the jurisdictions of the bodies. And when you first read Zimmer, if you don't take the time to read the footnotes, you kind of miss out on half of what this court said. And deep in the footnotes, over, I don't know, there are 90-some footnotes in this opinion. The footnotes tell us and inform us the original jurisdiction this court recognized sits with the district council on special exceptions and zoning map amendments. I don't know how much clearer it can be. This court figured it out. We looked at the land use article and we figured it out. So there's no ambiguity as to who has original jurisdiction. What amicus did was try to introduce this concept of, well, the General Assembly came back and said that the district council has to provide for an appeal to the district council if it delegates to a ZHE the original fact finding on a special exception and zoning map amendment. And that didn't divest the district council of its original jurisdiction. It just was a procedural rule that said if there is an Office of Zoning and Hearing Examiner, because let's recall, the land use article, the General Assembly through the land use article did not dictate to the district council that it had to establish an Office of the Zoning Hearing Examiner. It is permissive. So if the district council never established the Office of the Zoning Hearing Examiner, of what import is the rule the statute with regard to appeals? None. So this is nothing more than a procedural requirement that the General Assembly said, okay, folks, if you're going to have an administrative hearing examiner, and Montgomery County also has one, then you must allow in Prince George's County an appeal to the district council. So all this discussion about political and introducing a political aspect to what is going on makes no sense, because the General Assembly knew what it was doing, knew what authority it had delegated to the district council, and then and then told the district council, if you're going to establish an office of the zoning hearing examiner, then you simply have to provide for an appeal to the district council, who then issues the final agency decision. It is the final agency decision that each court then reviews: the circuit court, the Court of Special Appeals, and now this court. So the amicus brief, it doesn't advance the discussion any. It just tried to introduce a way to get around original jurisdiction, just like the district council could not confer upon itself original jurisdiction in planning board cases with regard to CDPs and SDPs in Zimmer, nor can the amicus say, well, we think this one phrase appeals, which it then extrapolates out and says, well, the General Assembly used the word appeal to mean appellate jurisdiction. That's not what it meant. The word appeal is used in other places in the RDA, and nobody stands up here and argues that that word then means appellate jurisdiction. The reason why Zimmer is important here is because Zimmer informs us that you have to look, where does the original authority come from? So where do you look for what the jurisdiction is? You go back to the RDA, and what is the original authority given to the particular body? And it's from there that it springs forth who has the final agency decision-making authority. In certain instances, it's the planning board. In other instances, it's the district council. When the district council created the zoning hearing examiner's office, it was very careful to use the term recommended disposition. We are asking the ZHE for recommendations with regard to findings of fact and conclusions of law. This was also important to this court in Zimmer, and again, you find it buried in a footnote at 74. And this court talked about, it is noteworthy that, unlike with respect to zoning map amendments, the RDA does not refer, either as contained in the land use article or Article 28, to planning board determinations regarding detailed site plans as recommendations. So even in this footnote in Zimmer, this court was recognizing that the word recommendations meant something. And what did it mean? It means that if the word doesn't appear, you have final determination. If it does appear, you don't. You're just simply issuing a recommendation to the next body if there is an appeal or the district council calls it up. Now, I'd like to touch upon just briefly, Mr. Nelson and Mr. Kumar have talked about extensively the Open Meetings Act, and quite honestly, obviously we are not the deliberative body, we are the applicant, but we were there at the hearing. And leaving aside how this court defines deliberation or consideration, I think it is highly relevant to any discussion with regard to the Open Meetings Act or what has to be discussed. You have to point us to something. You have to show us where are the statutes that control or inform the body of what their behavior is supposed to conform to. So is it that Mr. Nelson is saying that this body must sit there, pull out the Prince George's County Code, and literally walk through every single element in front of the deliberative body, and they have to review it all together, and they have to take a vote and walk through every word? And what is the standard to be applied here? How far do we force a body to go in its, quote, consideration or deliberation? If you have the record in front of you and you can read the entire record, this court doesn't ask me about every single word in my brief or every single question that's been raised. Same with the district council. And if you go back and look at the transcript, which was part of the record, and we've cited to some of that in our brief, the council members asked specific questions about certain provisions within the special exception requirement. Now, the district council member did not sit there and say, well, now I'm going to refer to, this section of the code, but they talked about architecture. And there were some concerns by some of the council members about the architecture. What is it going to look like? Is it going to look better than it does now? Are you giving the building a facelift in addition to the expansion? They talked about flooding. They talked about the DPI and their review of the flood plan. They talked about the fence in back. What's this fence back here? They talked about the setbacks. They talked about any number of questions that came up.
There were questions about some of that.
Yes.
But did they discuss in a deliberative fashion did they come to agreement on any of that?
So again,
in the open meeting,
it goes back to, if you ask me a question that your colleagues also want to know the answer to, and I answer it. But
we don't deliberate.
I understand that, but I'm just saying, and if I answer the question and therefore in their minds answer their question, is there anything left to?
Right, but we will vote in private. Our deliberations are not covered by the Open Meetings Act the way.
I understand.
The
My
district
point was
councils.
more that if someone asks a question and that question in the other council member's mind answers their question with regard to the 100-foot setback, what is there to talk about?
Well, that just goes to the other member didn't ask a question. Did the members come to agreement on any of those issues in the course of the open meeting?
So again, I don't know what agreement means. Your final vote is either your agreement or disagreement with how the outcome of those questions are answered.
Or did they state positions even?
Some of the council members did, had said, okay, I understand what you're saying, I get that, or, okay, I'm following.
But they didn't express a position on the particular elements of the special exception.
But that's not true. I would say that when they sat around and talked about the architecture, they were expressing their distinct views on what the building looked like, what it was going to look like, how it affected the shopping center.
And that fit into a specific, in which element of the special exception?
The architecture, like that the architecture be, these are my words, not necessarily statute, but that the architecture be consistent with what is in the shopping center. So
they, in your view, agreed upon that in the deliberations?
Or they were satisfied with the answer that they were given, and therefore they didn't feel they had to go any further with asking any more questions. I mean, that was the case for any number of these issues. These issues were addressed, and when I say issues addressed, I mean questions were asked. It's not as if they walked in, a document was handed to them, and they walked out.
Excuse me, Councilor. You seem to be making an assumption that silence on the part of those who are not posing the question and receiving some response by their silence suggest I'm with him or I'm with her or I buy that argument. You can certainly appreciate the challenge that we have here in posing these questions to you, because deliberation, perhaps in my mind only, and perhaps with my colleagues as well, means something more than just taking in information and maybe hearing in isolation one person's comment without another person's reaction. The conversation among the deliberative body is, I guess, what I'm hearing Judge McDonald ask you about. I'm wondering myself.
Let me put it to you this way: if I'm in front of the trial court, one judge deliberates, who does he or she deliberate with? Is that make it any less a deliberation because I have one judge and that judge doesn't necessarily have to talk to anybody else to come to the conclusion that they reach?
He or she doesn't, because it's a one judge decisional body.
No, I
This
agree.
is different. We're talking about the district council, aren't we?
I understand we're talking about the district council, but I'm also trying to get at what is the definition that you're going to impose upon a quasi-administrative judicial body as far as what they have to do to deliberate.
Isn't your point that you have a document? The document addresses all of the criteria, and that the deliberative body is meeting in public, they're convening, they have the right to ask questions, they have the right to discuss, but their act of voting on that document, which addresses all the factors, isn't your position that that act is the act of deliberation?
That is our position, that when you vote to approve or disapprove, you've now expressed your opinion about what is in the record, what you've heard, what has happened. And that is how that particular deliberative body answers that question. So thank you. Thank you, Your Honor.
Thank you, Ms. Bruce. How much time does Mr. Nelson have remaining? All right. We'll keep it to 7 minutes, Mr. Nelson, okay?
Thank you for the opportunity.
Yep.
So we've now established that this council decision was made before the hearing even began.
What evidence on the record establishes that? What I think I'm hearing is perhaps there were maybe discussions between an individual member or members and a council outside of a quorum, but no decision.
Well, Mr. Kumar just told this court not more than 20 minutes ago that the decision was made before July 18th in response to Judge McDonald's question. That was the basis for my statement that we now know the decision was made before July 18th. But if we look at just the record itself, we can read the transcript. There was no deliberation on July 18th. There was then, on less than 24 hours later, there's a 51-page opinion, which included 27 pages on 27-317. There was no deliberation on the 19th. I say that's evidence that the decision was made, and there was no deliberation. Now, Walmart argues, well, there was deliberation. And Judge McDonald pushed counsel on that question, and she responded by saying architecture. This is why I very carefully opened my remarks about saying there are two ordinances, 27-317 and 27-348. And I said there was no discussion about 27-317, and there was no deliberation about either. But architecture is part of 27-348. The setback is part of the variance. And if you go to my reply brief at pages 3 through 5, I very laboriously go through each of Walmart's assertions that there was a discussion. And I point out, and it's a tedious part of the brief, I try to give it as short as I could, but I point out that the citations and the reference in the record to which Walmart made didn't relate at all to 27-317. So, Judge Booth, we assert the decision was made before July 18th, based on what Mr. Kumar told this court, and based on the evidence in the record. We assert there was no deliberation on any issue on July 18th or July 19th. We assert that Maryland administrative law, as distinct from the Open Meeting Act, requires deliberation. We assert that the explanation of how this decision was made is further proof as to why we need to keep the politicians out of this process, where we need an independent zoning body, as we have in Montgomery County, in Baltimore County, Anne Arundel County, people who aren't elected politicians making these decisions.
But you're preaching
Counsel,
to the
that
wrong
has
choir
nothing to
here.
do with the issues before
Yeah,
us.
exactly.
I disagree, because the fundamental question is, I disagree as strongly as a human being can disagree, because that goes to the original jurisdiction piece. And that if you go to the legislative history, we have the Attorney General's opinion talking about land use generally, which we cite in our papers, where you want to keep the politicians out of it, out of these land use decisions. We have the 1971 bill creating the role of the zoning hearing examiner, saying that the appeal from the zoning hearing examiner to district council is an appeal like any other appeal throughout the land, meaning an appeal on the record, appellate issues. So, yeah, I say it's the central issue in this case, because if they have original jurisdiction, they can revisit all the facts in the case. They can make their own factual findings. We say they got to deliberate, right? They say you can't delegate to the principal counsel, but they got to do that. But if they have appellate jurisdiction, you take the politics out of it, and they're using the classical judicial review standard, administrative review, substantial evidence, legal correctness, etc. So, for all those reasons, we urge this court to vacate the decision of the lower court with instructions to remand it to the district council for proceedings consistent with this court's order. My clients been struggling with this for years, and they're grateful that this court reviewed the case. Thank you so much for your...
Thank you, Mr. Nelson, Mr. Kumar, Ms. Cruz. The court is adjourned.
All right.